Good evening, everyone. My name is Richard Meyer, and I am the Interim Executive Director for the Center for Ethics and the Rule of Law, or CERL, at the University of Pennsylvania Carey Law School. On behalf of the Center, I would like to welcome you to the second in our series of book talks this academic year. CERL is a nonpartisan interdisciplinary institute dedicated to preserving and promoting the rule of law in 21st century national security, warfare, and democratic governance. We draw from the study of law, philosophy, and ethics to answer the difficult questions that arise in contemporary transnational conflicts, as well as interstate challenges to democratic principles. To submit a question for today's talk, please use the Q&A feature found on the ribbon at the bottom of the window. Please keep your questions to both topical and appropriate. Anyone posting inappropriate language or content will be removed. If you are seeking CLE credit for today's event, please note that CLE codes will be presented twice per hour. Therefore, there will be 3 codes given during this session. Write down these codes and enter them on your digital evaluation form once the event is over. You should have the form already, but if you need another copy, the link will be posted in the chat. The evaluation form is mandatory to receive CLE credits. These codes will tell us how long you attended. The first code for this session is Pennsylvania. At this time, it is my pleasure to introduce the moderator for today's talk, Professor Claire Finkelstein. Claire is the Algernon Biddle Professor of Law and Professor of Philosophy at the University of Pennsylvania, as well as the Academic Director of CERL. Claire?
Thank you so much, Rich, and thanks to all of you for joining us today. I'm delighted to introduce our speaker, Bart Gellman. Bart is a critically honored author and journalist. He's a staff writer currently at The Atlantic and a senior fellow at the Century Foundation in New York. For many years before that, he was at the Washington Post. In addition to the book we are going to discuss today, called Dark Mirror, Edward Snowden and the American Surveillance State, he is also the author of Angler, the Cheney Vice Presidency, and his awards include the Pulitzer Prize, an Emmy for documentary filmmaking, and the Los Angeles Times Book Prize. Welcome, Bart. Thank you so much for joining us today.
My pleasure.
Before we start to talk about Dark Mirror, it's a fantastic book, I want to talk about another piece of writing that you've recently been on air talking about a lot, and many people have been talking about all over the place, which is an article that you published in The Atlantic called The Election That Could Break America. Since we're here just a few days away from the election, I'd like to spend a few minutes talking about this. And then when we turn to the book, I'm also going to invite Shawn Turner, who is a member of our executive board, to join us for the conversation. So the election that could break America, the argument that you make is, Donald Trump will never concede. This is not a guy who has concession in his vocabulary. But people are worried about the wrong thing. When people think, well, he'll never concede, he'll hunker down in the White House. There was a discussion recently about whether or not the military would assist in removing him. You say that's not how this election could go awry from a guy who intends to hang on to power. Can you talk a little bit about that, Bart, and what your disaster scenario would be if Donald Trump loses and nevertheless tries to hang on to the presidency?
Sure. What I meant was that the risk is not that he will lose and then refuse to leave. The risk is that he uses his power and the power of the presidency to prevent a decisive outcome from being reached or prevent it from happening quickly. And there's a lot of damage done in the interim. And so he's going to be seeking to create ambiguity around the result and chaos rather than simply saying, well, I lost, but I'm not leaving.
Yeah.
It turns out that refusing to concede is an immensely powerful act, and we've never seen it before. It hasn't happened that way in this country. And that if you refuse to concede, you are depriving the nation of the principal mechanism we've used to decide elections. That's how we end elections, is when the loser concedes. And we'll have to find a substitute mechanism for it if Biden gets the most votes and Trump won't conduct that ritual.
So paint the scenario for me. Let's say there's a count going on, possibly a recount. It could turn on the state I'm in right now, Pennsylvania. And it looks as though Pennsylvania may indeed be the state that potentially decides the election. What do you see? I mean, is this a Florida 2000 scenario where it ends up going to the Supreme Court, or is it he's calling Bill Barr at the Justice Department and trying to requisition ballots, or what's the scenario?
Well, it's a good question. And there's no way that any of us are going to be able to forecast the exact scenario, because it will be stranger than we expect, but it will be unusual. We're not going to have a normal count. But Trump begins right away on election day to say that there are early signs of cheating, that there is extensive voter fraud going on. He will probably fix his attention on particular urban areas where Democratic support is highest. He has mentioned Philadelphia quite a few times, and so that's of relevance here. And he will be filing suit in court on many and varied grounds. His poll watchers will be challenging every mail ballot that they have the opportunity to challenge in certain precincts. It may be that the state legislature gets involved. The Pennsylvania state legislature formed, then withdrew, but could form again without any notice an election integrity investigative panel, which would have subpoena power and would be able to call in election administration officials for questioning or to produce evidence, including ballots, for example, while the count is ongoing, and could therefore disrupt the count. Could make a finding, a legislative finding, based on the fact that Republicans control both chambers of the House in Pennsylvania, that there has been fraud, and in general create a conflict of authorities over who won.
And of course, we have a Democratic governor and a Republican-controlled Pennsylvania legislature. And so we could see that play out in a very contested way. And then add to that the fact that the Supreme Court yesterday decided to leave intact the Pennsylvania decision and its earlier decision, not to disrupt the 3-day window past Election Day in which mail-in and absentee ballots could be counted in Pennsylvania. However, several of the justices reserved the possibility that these ballots could come into play later. And so they are being set aside separately from the other ballots, apparently, when they arrive, in case they are contested.
Right. Well, the term used in that dissent was a targeted remedy, which sounds a little ominous in this context. The clear implication is that they're going to set aside ballots that come in after Election Day, and they will know how many ballots there were, and that post facto, the Supreme Court could decide that they shouldn't be counted. People cast their votes with the understanding that there would be a 3-day grace period, and mailed them in, and the votes get counted, and then they get uncounted by the Supreme Court if they get one more vote on the conservative side.
Right, and of course they very well may have another vote on the conservative side, because Amy Coney Barrett, newly confirmed to the Supreme Court, did not weigh in on the decision, the Pennsylvania and North Carolina decision yesterday, saying that she had not had time to read the briefs. Well, if this comes up again in a couple of weeks, then presumably she'll be in a different position. There's one more scenario, and I don't know if you have any thoughts about this, but if the results of the election are uncertain enough and are truly undecided, this could end up in the House of Representatives, in which each state has one vote. We've almost never had to face that situation before. I think we faced it one time in our country after the Civil War. Do you imagine that is a realistic possibility here? And could it be that Donald Trump, who would probably be advantaged by a vote in the House, could try to make the results of the election as unsettled as possible in order to throw it to the House?
Well, there are more probable scenarios. That one is based on the circumstance in which no one receives a majority of the whole number of electors, which means 270. No one received 270 ballots. When that has happened in American history, it's been that there were 3 candidates who each received a substantial number, and there was only a plurality victor. It can happen because there are 538 electoral votes in total, that there's a tie vote at 269 ballots each. And you can find on 538.com scenarios in which that happens, maybe with a 1% probability or less. But the likelier disputes in the Electoral College would come if, say, for example, Pennsylvania, the Pennsylvania legislature declared that it couldn't trust the vote count, that it had been marred by fraud, that the whole thing was a hopeless mess, and that the legislature itself was going to have to select electors to send to the Electoral College. This is a power reserved to the legislature in the Constitution in Article 2. And the Supreme Court said in Bush against Gore that Congress, that the legislature can take back that power at any time from the people. So we have a vote, but according to the Constitution, we don't actually have a right to vote for president. The legislature grants us that right, but can otherwise appoint. So the conflict would come if the Republican legislature said, the vote count's rigged, it's no good, we're going to appoint Trump electors. And then the governor, who is, as you said, a Democrat, at the same time certifies the actual vote that was taken and sends in to the National Archives and to the President of the Senate a slate of Biden electors. So now there are 40 people who are purporting to cast the 20 electoral votes that Pennsylvania has. And it goes to Congress to decide who has the legitimate claim to control those electors.
Perilous times. What do you think the reaction would be in the country? I mean, we expect people to take this calmly, or could we expect to see real, potentially violence in the streets?
Oh, I think it's going to be pandemonium. I think there will be a great deal of tension and conflict and potential for street disturbances just from the get-go, when the president starts saying all this fraud I was predicting is now actually happening. They are stealing your vote. That is his message. He has said that the only way he could lose, is a rigged election. He has ruled out even the possibility that voters could make an actual choice to unseat him.
And in fact, he's also said that he may not abide by the results of the election if indeed it's not a winning vote for him.
He has said that repeatedly. And so his supporters are going to be on the lookout and energized. He has recruited what he calls an army for Trump of poll watchers. He has asked them to be on guard. He's asked the Proud Boys to stand by in case the election is being stolen. So he's laid out all the tinder, and I don't think it'll take much of a flame.
One more thing I just want to cover from this article before we go on to your book, Bart, is you wrote in the article about the consent decree that was previously a court order that expired in 2018. that prevented or purported to prevent Republicans from trying to manipulate the election results and poll results. Can you talk a little bit about that and what impact you think that's had?
So this is going to be the first presidential election in 40 years that does not take place with judicial oversight over the Republican poll watching efforts. This originated in a lawsuit of the Democratic National Committee against the Republican National Committee back in 1981, after the gubernatorial election in New Jersey, when Republicans, doing the same things that they have done for decades, sent off-duty cops and sheriffs wearing armbands and carrying radios and calling themselves, sort of an election patrol. They were stopping voters, warning them of the felony penalties for casting a vote when you're not entitled to, or if you're not properly registered. They put up signs. They got in the face of poll workers. They physically prevented poll workers from assisting voters who needed help filling out their ballots, which they're entitled to have. And they generally did their best to intimidate people and prevent them from reaching the polls. So it was classic voter suppression. The consent decree gave a judge authority to review in advance of every election, nationwide, all of the RNC's poll watching election day operations. And it prevented the RNC from mixing its budget and its people with people, for example, of the Bush campaign. But now they're fully integrated under Trump. They're part of the army for Trump. No judge is watching, and any remedies that may be available, if they go too far, will come only after the fact. There are no do-overs in elections.
That's right. That's right. Well, those are some sobering thoughts, Bart, and we look forward to your next article, which I gather you're working on now. This is really important work that you're doing, as all your work is. Let's turn to Dark Mirror now, which may not seem to be quite as much of a change of topic ultimately, because we're going to come back around to the Trump administration and talk about some of the themes of this book as they impact what's going on today. But let me ask you to begin by inviting you to talk a little bit about the personal side of writing this absolutely wonderful and gripping book, which once I started it, I could not put down. And shortly, I'm going to invite Shawn Turner, a member of the Searle Executive Board, who you know very well. I'll introduce him momentarily. But first, let me ask you what it was like writing this book for you. One of the things that's so striking about the beginning of the book is the level of sort of anxiety, stress, the fact that even a seasoned journalist like yourself, even at the beginning of this project, how overwhelmed you were by the sheer level and volume of documents and complexity of the documents that you received. And as you're sort of narrating this in the book, you're talking about, oh my God, am I prepared for this? How do I handle this? I've never encountered anything at this level. So just describe for us in more detail what that was like and how you managed to move up the learning curve so quickly to digest all this this volume of information you were receiving.
It didn't feel quick, I'll tell you that. So as you're suggesting, the book is very personal. The Dark Mirror is really three narratives. It's a narrative about the development of a surveillance state and the way it expanded past old boundaries after 9/11. It is a book about Edward Snowden and who he is and how he did what he did. And it's a book about me and my interaction with that national security state and my interaction with Ed Snowden, which began when an anonymous person who called himself Virax, or truth teller in Latin, arrived in my inbox with promises of a very big scoop about overreach by the national security state. He wouldn't say who he was or anything about himself except that he was in the intelligence community. And we began a long set of conversations over anonymous and encrypted means in which he was trying to figure out whether he could trust me as a member of the mainstream media to tell his story. And I was trying to figure out whether he was authentic and whether I could trust him to tell me the truth. And so once the materials finally arrived and I found that I had gigabytes of highly classified National Security Agency files, I was overwhelmed by it. I should set this in context. I'd been writing about national security for many years as a longtime Washington Post correspondent, although I had left the Post in recent years before the Snowden archive arrived. I'd written about lots of things that were classified in the sense that if you had the original document that described it, it would have a stamp on it. But if a president is talking about, if you're talking about sort of confidential diplomacy or military planning or almost anything you want to know as a national security correspondent, it's going to be classified at some level or another. But nobody in the Washington Post newsroom had ever had even one document that was a contemporary code word classified above top secret document about a contemporary intelligence operations. And I suddenly had 50,000. And I had no idea how I could work with all that. And I also came to believe immediately that there were things in there that I should not publish and that should remain secret. And that I therefore had to learn how to protect them as best I could from being stolen by outside parties. I mean, my threat model as a national security reporter had until then been largely that the US government would try to go after my sources. And so I needed confidentiality and security to protect my sources. And now for the first time, my threat model was that foreign intelligence agencies and hackers were going to come after this stuff. Because, I mean, as soon as the first story published, it would become evident that I had a lot of things that were not published that came from the NSA, and I was going to become interesting to people that I didn't want to be interesting to.
This seems like the perfect moment to invite Shawn in. So Shawn, if you can unmute yourself and put your camera on. Wonderful. Thank you so much for joining us. Shawn Turner is Professor of National Security Communication at Michigan State University and an on-air national security analyst for CNN. He's a former Marine Corps officer and senior executive in the U.S. intelligence community. While in government, he served as an assistant press secretary for foreign affairs at the National Security Council and the director of communications for U.S. national intelligence. And the deputy White House press secretary for national security. And in fact, Shawn, you were the basically running communications for Director Clapper when the Snowden revelations hit. So you were the perfect person to talk about this with us. Bart just said, and I know you two have actually had a chance to talk about a fair bit of this. So for you, you may be recapping old debates, but for us, it's all new to hear you talk about it. If you can talk a little bit about your experience when you first found out that this information was coming out, how did you first learn about it? That's partly perhaps described in Bart's book about a meeting that he had with Director Clapper. But maybe you can tell it a little bit, narrate it from your side.
Sure, Claire. First of all, thanks for having me. And Bart, it's good to see you. I haven't had an opportunity to get through the book completely yet, but I'm looking forward to reading it. And it's good to be on with you. Um, let me, let me just give a little bit of context. And I was listening to Bart. It's interesting to hear sort of his perspective on what he was feeling at the moment that he realized that he had something so significant. And I think it's a good time to sort of talk about that from the perspective of what we in the intelligence community realized we're realizing at that very same moment. So I'll never forget the day when we got that initial call telling us that, asking us about a program that was a highly classified program that the intelligence community had run. I remember the description of the program and immediately calling our general counsel saying that, I just got a call from a journalist asking about a program involving the collection of telephone records that the intelligence community is involved in. And I had heard about this program and I knew what it was, but we just thought that was, there must be some sort of mistake here. Well, this started a whole series of events in the intelligence community where we began to slowly realize that it wasn't just about one program or two programs, but it was about a lot of programs and some of the most highly classified and most sensitive active intelligence programs, foreign intelligence collection programs that we had currently underway. And just to give people a sense of how this felt in the intelligence community, as intelligence officials, live day to day with the understanding that if they make a mistake, if they miss something, then that can have significant implications for our national security. And so here we are in a situation where we don't know who has possession of these documents. We don't know a lot about what programs have been exposed at this point. And what we're concerned about at this point is intelligence streams of information drying up. We're concerned about the people that we are watching and the organizations that we're watching that we know exist to do harm to the United States and to do harm to Americans. We're worried about losing the thread on those individuals and being able to continue to track them and do our job. So that was the primary focus for us, was what is this going to cause us to miss? Now, of course, beyond that, we begin to think about all the implications of what this means in terms of these programs being exposed and what's been taken. But the mood in the intelligence community, the mood at NSA was one of immense concern and just a sort of anxiety over what we were going to miss and what had been exposed.
And let's break this down a little bit more, because there are two programs in effect, Bart, that you received information about. One was the 215 metadata program under the Patriot Act, and the other is the PRISM program under Section 702. And can you talk a little bit about, did you know about anything to do with either program, or was it all completely new to you?
So just to amend that a little bit, those were the first two stories that became public, and they were two of the big programs that were discussed. But there were many other important revelations and programs that were discussed as the coverage continued over a period of months and up to over a year. Right. The telephone metadata program was this. It never was completely universal, but it aspired to log every telephone call that was made by anyone in America to anyone else anywhere. So it was a complete record of all telephone calls, and it was gathered for the purpose of doing something called contact chaining, which is when you have a subject of interest in the intelligence world, you can see who his friends are and the friends of friends and potentially the friends of friends of friends, and find links to unknown associates in that chain. It's a very sophisticated form of big data analysis. But in order to do that, building the first link of a chain on everyone. There was essentially a gigantic social network being drawn by the US government from all the data that it was getting from phone companies. No one had any idea that was happening.
Now, right now, you're talking about the 215 program.
That's
So,
under Section 215 of the Patriot Act.
of the Patriot Act. And so just so our audience understands this, when we're talking about metadata, we're not talking about the content of the data. It's like the outside of the envelope in a
Just
letter.
who calls whom, how long
Right.
they talk, when they talk.
Exactly.
Metadata could also include location. That information was actually reported to NSA through the FBI, but they said they didn't store it.
Exactly.
That was the first of the two programs you're mentioning, and I'll just quickly sketch the other one. PRISM was the cover name for a setup in which the US government would obtain the content. This was with warrants. These were secret warrants that were issued by the Foreign Intelligence Surveillance Court. The government would go in and say, I need a warrant to get all of Finkelstein's data, and could get it from Google, Facebook, AOL. There were 9 at the time I reported it, large internet companies that were providing the data. And it could be years and years of material. It could be gigabytes of data from, people don't clear out their email accounts. It could be documents and spreadsheets. It could be family photos, whatever. It was an intent to get a sort of full, rich vein of information about the subject. And it was done with a warrant, but it was done in a new kind of way. Instead of having an individual target and giving individual reasons why there's probable cause to believe that this target has foreign intelligence value, is the agent of a foreign power, there was a set of rules agreed in which the NSA could simply list names, send them by way of the FBI to the internet companies, and the judge would have essentially authorized in advance that any name the NSA sent would be treated as a valid warrant. And the NSA promised to obey certain rules about how it would do its targeting. But it meant that this kind of highly intrusive surveillance was being done on a scale that had not been done before. There would be on the order of 100,000 people at once at the same time that were having their data sort of siphoned.
Now, an interesting thing is that the 215 program was eventually found in a case called ACLU against Clapper to be illegal, not on constitutional grounds, but on the grounds that the 215, among other things, the 215 statute did not specifically authorize it. But Shawn, maybe you can weigh in here and say, I mean, how important was to intelligence efforts was the ability to get this metadata, and how much of a loss was there when the program had to be dismantled from the standpoint of the IC?
Well, I think some of the listeners may find my response to that surprising, Claire. If I can back up for a second, just with regard to Bart's comment, Bart's absolutely right with regard to what the 215 program did. I would just add that in order to look at that, as you described it, Bart, that social, sort of a social network that was being created, as we all know, this wasn't something where any intelligence analyst could simply go and look through the data and figure out who had called who at what time. There are rules in place that allowed the intelligence community, that allowed NSA to go and take a look at that data at times that were appropriate. But I will say that, and this is what I think most people might find a little surprising. When we look at the BR-215 program and what preceded the program, and I've said this before, I think this is one of those areas where the intelligence community made a mistake. I think that the program is a program in which, in the aftermath of 9/11, when there was much more of an appetite in this country for measures that might help us identify and identify the individuals who would attack us and to protect the United States, I think that the American people would have had much more of an appetite for being told about the BR-215 program, being told about the business records program. And I believe that at the time that it may have been widely accepted by people because of the purpose. Now, that's, we don't know whether or not that's the case, but I think that this is one of those cases in which we should have been much more transparent about this particular program. You ask what the significance of the program was. To be quite candid, without getting into too much detail, I don't think that the intelligence community lost a lot with regard to the program going away. I really don't. When we look at the amount of times the program was used and the amount of information that it provided, I would say that we have means to protect this country, to identify people who are communicating outside of this country, people who are plotting against this country. I think we have authorities through other means that allow us to do that without collecting the data, the metadata of every cell phone here in the United States. Some people might find that surprising, but I don't think that this program was a huge loss for the intelligence community.
Now, by contrast, I'll just ask you to finish on this, Shawn, and then I'll go back to Bart. The 702 program, you might feel a little differently about.
Oh, yes. Absolutely. The Section 702 program is perhaps the most important program that the intelligence community has for targeting and collecting information on foreign targets outside of the United States. This program, within this program, the provisions of the FISA Act, this program allows us to not only identify and to track and to follow individuals out foreign targets, but also it has, and Bart may disagree with this, but also, it does have effective means for making sure that we are not violating the civil liberty and privacy rights of every American. I think the central concern here was what we call incidental collection. And this is just the idea that when you look at collection outside of the United States, inevitably you are going to come into contact with, sweep up data that is U.S. person data. There are minimization procedures to make absolutely sure that that data is not accessed in a way that violates people's rights even outside the United States. But nonetheless, it does happen. But without a program like this, the United States, the intelligence community simply wouldn't be able to do its job to protect the American people.
So that's very helpful. So Bart, just again, there were other programs, other sorts of information was disclosed, but just comparing these two programs in terms of thinking about your own decision about what to reveal and what not to reveal. In some sense, you were proven right on 215, at least if you credit the ACLU against Clapper case and the court's decision there that it was an illegal program. The court eventually struck it down, though, as they say, not on constitutional grounds. So we don't know whether or not ultimately, if it were to return, it would stand up to Fourth Amendment scrutiny. But you revealed a program that a court eventually shut down. But on the 702 program, not the case. So, how do you feel about your own decision, looking back, to reveal the identity of these programs and thus, in some sense, to reduce their usefulness?
So there's a lot going on in that question and in Shawn's remarks also. And I appreciate the sort of considered tone that Shawn is taking now and always took. My interactions with the U.S. intelligence community varied widely, let's just say, during the period of the Snowden leaks. And sometimes the interchanges were hot and emotional, and sometimes they were cool, and Shawn was a voice of reason all the way through, which I appreciated then and now. What Shawn said about the value of the 215 program is pretty much the consensus now in the intelligence community. It is, at least it's the prevailing view, that they wanted it. They thought that it might produce some really valuable information, but it didn't turn out in practice that it did. If I were a member of the intelligence community and was held to the standard that nothing bad could happen in the world that I had not foreseen and alerted the government to, and anytime something bad happened that I didn't foresee or detect in its early stages, that would be a gross failure of intelligence, then I would want access to all the information in the world. And a president never feels that he's got enough information to deal with all the challenges of the world. So I know why they want all that. It doesn't mean that our considered judgment as a society should be that they get all that. There are other values in play, and there are things to balance out with that, and we have to draw lines. I mean, just like we don't give the police every tool that the police might like, or we would have a police state. The 702 program is much more valuable and productive of intelligence. And in fact, in my very first conversation with Shawn, on the day before I was going to write the story about the 702 program, I said that there are things in this document that I already know I'm not going to publish. It was a 43 maybe page slide deck. And he set up a conversation in which Bob Litt, the general counsel for the intelligence community, and a bunch of subject matter experts, sort of unidentified off in the background of this conference call, were there. And the first thing I said is, to speed this conversation, and maybe to ease your minds a little bit, nothing between pages 15 and 25 do I intend to write about. Because I looked at those things and I saw that they would have blown very specific operations. They were records of conversation that alleged terrorists were having in the field. There was proof in there that a country that is an adversary of the United States was lying about one of its WMD programs. There was proof in there of a cover-up by another country and the cover-up infringed on U.S. interests. And if I had written those stories, then those sources of information would have simply vanished. It was not my intent to stop intelligence programs. It was my intent to discuss what the boundaries were in a way that had been obscured from the American people.
So how did you make the decision of what to hold back and what to publish?
Well, some of them were easy, and I didn't even have to consult with the U.S. government. I just knew I wasn't going to publish that. You find a name and photograph of a clandestine U.S. operative working in the field, you're just going to leave that one alone. Whereas there were other ones that I thought were hard questions, and there were sometimes cases when I was surprised by a U.S. intelligence request, because the conversations, when they worked well, went like this. I would say, I'm looking at a document with this title and date and author, and I'm going to write a story about the way this program works. And I'd like your comment and context for it. I want to make sure I understand it correctly. It was understood that the government could say, we don't want you to do that. But normally what the government would do was say, for the record, we don't consent to the publication of anything at all that's classified. But what we really care about is this thing on page 7. What we really care about is that you not disclose this particular capability against that particular adversary, and so on. And sometimes often it was obvious to me in advance what would be sensitive. And sometimes they would say, this is sensitive in ways that you may not suspect. And they would even occasionally tell me things that I didn't know in order to explain to me why I shouldn't publish something that I did know. Those were decisions that we reserved to make ourselves at the Washington Post, but we were very much influenced by good faith conversations like that.
Did you wrestle with the fact that you were disclosing classified information at all? So were you not a journalist and protected by freedom of the press of course, you might have been charged with a crime in conjunction as part of Snowden's crimes of revealing classified information, being the vehicle for that revelation. Now, there have been times in our history, most notably and somewhat surprisingly in a way under the Obama administration, where the threat of journalists being prosecuted under the Espionage Act has seemed more than merely theoretical, as journalists who you know well and remark on in the book, seeing their names in the material as well, could tell you. But having this, in a sense, having it be the First Amendment that stands between you and that, how did you feel about that as you thought about it?
I was very, very concerned about doing the right thing as best I could figure out what that was. But certainly I was concerned about legal exposure as well.
Mhm.
And the lawyers at the Washington Post told me that I could be prosecuted under the Espionage Act, potentially, because the language of the Espionage Act is very, very broad. I think and I hope it's unconstitutionally broad if it were applied to publishing a story about national defense, because it seems or purports to make it a crime to talk about any national defense information. So if I say the Army has, 8 divisions, that sounds like national defense information. It's widely considered to be badly drafted and overbroad and a response to its times back in 1917. There's another part of the Espionage Act, 18 U.S.C. 798, which specifically forbids publication of information about communications intelligence. And so I was told that there was potential that I could be prosecuted for that. The likelier risk, which was not nothing, was that I would be subpoenaed for testimony and documents and be under civil compulsions to produce those. And then if I refused to discuss my source, or if I refused to turn over documents, if I refused to turn over notes, that could be held in contempt of court and held in jail until I complied. And I knowingly took those risks for the benefit of what I thought was a vitally important story.
Shawn, I want to turn to you. And of course, we are an ethics center and a center that examines national security questions from the standpoint of the rule of law. So this dilemma really is front and center in our thinking about this topic, and something we've examined before. But Shawn, from your point of view, should journalists reveal classified information ever?
This is a question that that we grapple with in government all the time, and I've gone back and forth on this, but here's where I've landed. There are absolutely instances in which a journalist will come into contact with information that is newsworthy, and whether it's classified or not, that journalist, that a news organization may need to make the determination that it is in the best interest of the public to have that information. Now, as I say that, there certainly are a whole series of steps that we would hope that a responsible journalist would take as he or she makes that decision and has that calculation. I will say that, it's for all the time I've been in this business, it's not unusual for journalists to call me up and say something on the phone that lets me know that they've seen a classified document. And we've always been, we've always been fine in that instance. We know how to deal with that. I will say this was different. And Barton, I've talked about this before. I mean, I think everyone understands why this was different. Bart mentioned that, he had made decisions about, looking at documents and determining that there were things he was not going to publish. And obviously from our perspective, at least that amount of consideration was so overwhelmingly appreciated. But it did not leave us without an immense amount of fear. The example that Bart used about, looking at a document and seeing, information about a clandestine officer working on a particular program. What we had to deal with in the intelligence community is that information was no longer behind our firewall of classified information. That information was potentially in a building downtown in Washington, D.C. And even if Bart was doing everything he could to protect that information, we knew that information was outside of our hands now. And for us, there were significant implications, not just in that example, but in thousands of examples where we had to stop and look at where this information was. And if it wasn't the United States government trying to get that information back, we knew that there would be others who wished ill will toward the United States who were trying to get that information. So obviously very challenging for us. At this point, when it comes to classified information, I'm a freedom of the press guy, and I think that you'll find that most people in the intelligence community are freedom of the press people who understand the immense value that the press brings to our democracy. At the same time, we struggle with the idea that a journalist or a journalistic organization might look at classified information and feel qualified to make determinations about what information is information that might bring harm to the United States if published. The last thing I'll say here on this is that the relationship that Bart described is one that really took time for us to develop. Bart might agree here that early on, no matter what, and if Bart didn't hear this, I certainly did. No matter what was going to be published, everyone in my sphere, all the intelligence officers said, no matter what it is, it's bad, it shouldn't be published, and people are going to die because of it. But what we had to do was we had to come to a point where between my relationship with Bart and the Washington Post and my team's relationship, and between our relationship with all of the intelligence officers, we had to find that middle ground that Bart described, where he'd call up and say, here's what we're looking at, here's what we're saying, and where we would say, oh, it's all bad, but what we're really worried about are these things. It took us a while to get there, but we are very fortunate, not only as an intelligence community, but as a community, but as a nation. We're very fortunate that we were able to get there. And I don't say that to suggest that I don't believe there was harm done here. I certainly do, and I've always held that. But I do think that this could have been much worse if it were not for the fact that we did get to a point where we could have those discussions and prevent some of the most egregious and harmful information from being published.
That's a fascinating discussion, and I wish we could continue on that theme, but I want to actually switch direction now and talk about something else, which is to talk a little bit more about Snowden himself, because I think one of the things that's so fascinating about the book is that it really paints an interesting portrait of Snowden and gives you a feeling for this person. And there's also one of the big questions is his relationship to Russia. There he's been hanging out in Moscow for a number of years. It was news to me. I always thought, oh, well, he fled to Russia. Doesn't that prove he had a special relationship with Russia, was a Russian asset? And you say, no, he ended up in Russia because he was changing planes there. And the US just happened to invalidate his passport right at the moment that he was passing through on his way to Latin America and ended up stuck in Moscow. And furthermore, you also voiced the opinion that there is simply no evidence to suggest that he was or is a Russian asset. Has anything since the time that you wrote those words changed your mind as of late, or do you still feel that it's just happenstance that he's in Moscow?
Look, I'm a journalist. I'm open to evidence. And honestly, for my book, it would have been an immense scoop if I discovered evidence that he was a Russian agent all this time. And I certainly would have published that. He was a self-motivated sort of activist hacker who became disillusioned with the intelligence world that he was working in, has a zealous and kind of black and white sense of right and wrong, And like other self-described whistleblowers I know, just couldn't tolerate the dissonance between the world he was working in and the beliefs he came to form. I have talked to lots of people in the US government about whether there's any evidence that he was a Russian asset, witting or unwitting, at the time he took the documents or afterward. And I've never had one who purported to know, who said that they had evidence of it. I didn't always talk to them on ground rules that I can share with you their names here, but some of them I did. I mean, Jim Comey told me flatly, and the FBI was in charge of the investigation of this, or parts of it, that there was no evidence that he worked for Russia at any time, that he was, he thought of himself as a white knight who was operating on his own. I don't think that Shawn's old boss, James Clapper, would disagree with that. And there are two deputy directors of the NSA who have said that on the record. I just think there are people who will say, well, he went to Russia, how obvious could this be? But he wasn't there on purpose. And it's not obvious.
Shawn, do you have any different view of this?
Claire, I don't have a starkly different view. We talked about this, and Bart's right. There's no smoking gun here. Now, I will say that for those people who will say, well, look at it, it's obvious. Well, I would say to that when you look at relationships that have been forged, and you look at the role of WikiLeaks and Julian Assange, and look, there are a lot of things there that might cause people to wonder whether or not there's something here. But as Bart said, he's a journalist. He looks at evidence. We're in the intelligence community. We look at intelligence, and until you have that, all you can do is sort of look at the circumstances. And there certainly is enough here to say, boy, this really looks like there's something to it. But until we have the evidence, we certainly can't say conclusively that he was ever an agent of Russia, or that he is now. But I will tell you that it concerns all of us that he's there, and it concerns all of us that all of this information may have passed through Russian hands.
Now, Shawn, I gotta just ask you this, because one of the things that most alarmed me recently and made me go back to my suspicions that Snowden must somehow have been a Russian asset was the fact that Donald Trump said he wanted to pardon him. So, what do you make of that? And then I'm going to ask Bart the same question.
Yeah, I've thought about that a lot in the context of how the president and how the current administration must be thinking about Edward Snowden. Again, I go back to the notion of evidence. I certainly believe that, when people look at this, it certainly looks like there's something there. I think it's possible that the president and the administration are doing the same thing, even if they don't have any evidence that Snowden is an asset of Russia. I think that when they look at the relationship between Julian Assange and WikiLeaks and the connections to Edward Snowden, I think they're seeing something there that may cause the president to say what he said. Again, we don't know if there's evidence, but it certainly stands to reason that that's why he said it.
Bart, what do you make of the pardon business?
I think it's possible that Shawn is overthinking it. It is, Trump is impulsive and transactional, and there are allies of his who think Snowden is a hero on the libertarian right. And we know that he's talked about this stuff with Rand Paul, who would love to see Snowden pardoned because he believes he believes that that the intelligence community assumed way too much power over Americans, that Snowden revealed it, and then he's a hero. When Trump floated that idea by his national security officials, he would have received nothing but shock and horror at the idea of pardoning Snowden. The NSA, the CIA, the Defense Department will be forever against a pardon for Snowden under any circumstances. Look back at the case of Jonathan Pollard, with so much political pressure brought to pardon him, and it took so many years before any president dared to do it.
And Bart, what about the
So
theory?
Well, I was just going to say, for Trump to get an ally to suggest an idea and then to have the deep state aghast must have been very tempting for him.
Right, exactly. Well, and what about the theory that, if Snowden wasn't a Russian asset when he went there, he's sure got to be now, because after all those years sitting there, you don't hang out in Moscow being as prominent as he is without Putin being pretty supportive of you.
Unprovable and too simple, I think. Too simple in the sense that Putin has lots of interests here. One of them is to see if he could squeeze a little bit more intelligence out of a guy who has already now given away, this gigantic archive. And intelligence is perishable, and there's a limit to how much could be in any one guy's head. There's a limit to how much could be in Snowden's head that wasn't in the documents. There is a perfectly decent chance that Russia obtained the full set of documents, not from Snowden because he didn't bring them to Russia. He wasn't carrying them. That's one thing. Snowden says, and he's a stubborn son of a bitch, he says that he was approached by the Russians, and he told them, I am not going to get involved with this. Now, keep in mind that when he was stuck at the airport for 30 days in Sheremetyevo airport, he had internet connection the entire time. He was on the computer every day communicating with journalists and activists. If Russia was going to squeeze him, they would have taken him into custody, and they would not have let him have that kind of contact with the outside world, or the contact he had every day with his ally who was with him. So it was
useful to them to be reading his correspondence.
Yes. Here's another way it's useful to them. Putin gets a cooperative Snowden who is happy and free and denouncing the United States. Right. And he gets to be the guy, Putin does, who is protecting a whistleblower who's under political persecution from the Americans who claim to be for civil rights, but in fact are trying to oppress this whistleblower. And he gets some public relations value out of that at no cost. So it's not true that the only reason he could possibly have for tolerating Snowden's presence is that Snowden is debriefing him.
We're going to start the Q&A in just a couple minutes, but there are two last topics that I want to address. One is Donald Trump's war on the intelligence community, which has been of longstanding with his administration and even before that, his fury with the Obama intelligence community for initiating an inquiry into his contacts with Russia, his attack on the Crossfire Hurricane investigation, and leading up to his actually having his Justice Department engage in subpoenas or near subpoenas, questioning of members of the intelligence community and threatening to indict them and prosecute them. The Durham report is, for the moment, on a shelf. It doesn't look like it'll be coming out before the election. So we don't know what that will lead to, but it's been a sort of sustained attack on the intelligence community. So here's my question to both of you, really, and Bart, I'll start with you first. Do you think that the anger against the intelligence community because of the Snowden revelations and the anger around the 215 program, in some sense paved the way for this messaging on the part of Donald Trump around resentment towards the IC? Did that kind of prepare the ground for an audience that was willing to believe in the Obama intelligence community as part of a deep state conspiracy?
I don't know. I doubt it was a big factor. I think that anything bad that's ever been said about the U.S. intelligence community, whether it was mistakes made on the assessment of WMD, whether it was torture, whether it was overstepping on surveillance, could soften up the target a little bit. But when you have someone talking about a deep state that's trying to thwart the president and control events and do evil secret things, I just think there is an audience for conspiracy theories. There's an audience for ideas that explain the world with simple villains. And he didn't, I just think, I mean, Trump didn't need the NSA stories to get his point across. I don't know whether Shawn sees that differently.
What do you think?
Well, I guess I would start by saying I think that President Trump would have attacked the intelligence community, whether we had the NSA stories or not. I think that the intelligence community was an easy target. So the question being, in terms of people's willingness to accept and the idea that the intelligence community might have been behaving in a way that was outside of legal bounds, were they primed to do that and more open to the idea as a result of Edward Snowden and the NSA stories? I would disagree a little bit and say that I think they were. I mean, look, it certainly was the case that if we go back and we look at some of the public discourse around the Edward Snowden affair in these articles, if you can separate out what Bart and his colleagues wrote all together and just look at what the American people were saying about the intelligence community, and they were saying things that weren't in the articles. They were concerned about intelligence officials listening to your phone calls and reading your emails and looking in your bedroom window and following you wherever you go. But these things were not things that were in the articles. But this atmosphere around the work of the intelligence community was, kind of grew up here in the country, and so it led to a lot of suspicion on the part of what the IC was doing. And one of the things I have to say this because it just is really important for people to understand. When we look at what the intelligence community was doing in terms of carrying out intelligence on behalf of the U.S. government, there's absolutely no evidence at all. There's absolutely nothing to suggest that the intelligence community was acting outside of the boundaries of the authorities that had been given by Congress. And so one of the things that's always been perplexing to me about this is that, of course, we had members of Congress who, there was manufactured outrage over what the intelligence community was doing, when we in the intelligence community knew very well that they were well aware of these authorities and exactly how these authorities were being used. But at the time, the last thing they wanted to have the intelligence community to say was, we are following the rules and we're operating within the authorities that we have been granted. So if you have concerns with those authorities, then the people you should be talking to, the place where you should be expressing those concerns, are with the people who make the laws. That was not a narrative we could adopt, but in reality, I think that we'd struggle to find anything that's outside of the bounds with regard to that. So a little bit off topic there, but I think President Trump would have done what he's doing either way.
Okay, fantastic. Why don't we get into the Q&A then now? So I guess they have been teed up in the Q&A link. I see a number of questions there, and let me start going through them. So first, I'm going to identify, because I have prior permission to do this, George Kroner, who's a member of our advisory council and longstanding member of the intelligence community himself. Now, this is a question that we already sort of touched on, but I'm going to go back to it and ask it in a little bit more detail or a little bit different way. So George says, given that you knew that the information that you had received from Snowden was classified, you acknowledged as much in your book, and related to the communications intelligence activities of the US, by transmitting information for publication, do you concede that you violated 18 U.S.C. 798? And would you agree that Snowden violated it?
So I'm going to decline Mr. Kroner's very kind invitation to confess to a felony. I will say that, as I mentioned earlier, the broader espionage statutes don't specify publication as an offense. Section 798 does. And so I will certainly concede that a prosecutor could plausibly make the case that I was in violation of that law. No one has ever been prosecuted. No journalist has ever been prosecuted for publishing national defense information about communications intelligence. Or in fact, no journalist has ever been prosecuted for publishing any classified information. And it has been widely understood that in our political legal culture of the 21st century and for the latter half of the 20th, that this was a boundary that would not be crossed, that we were not protected by the letter of the law as much as we were by a political and legal culture in which it was understood that there was value. It was partly protected by the First Amendment. There was a broader social function served by journalism in informing the public and in describing public interest things. And let's just keep in mind here, if no classified information had been published, we would not know about CIA torture. We would not know about clearly illegal surveillance that was taking place under the Bush administration, and that was later found to be and understood to be illegal. We would not know about the treatment of detainees at Guantanamo Bay. We would not know that the FBI was issuing tens of thousands of national security letters every year to sweep up American communications information without a warrant. These are all stories that led to significant reforms, because when society knew about them, the people collectively chose not to keep doing them, or lawmakers did, or courts obliged them to stop. These were not small things, they were big things. And so there can be harm in disclosing classified information, and you try to avoid harm in your selection of what you write about. But harm alone isn't a reason that's decisive to me about not publishing, because there could be corresponding benefits, and there's also controversial what counts as harm. So, I mean, if you publish a story and then Congress decides that it's going to make a reform in that area of law and publishes new, and passes new legislation to stop the program, is that harm? No, there's a loss of collection, but that's a feature of the system. It's not a bug. This is the system working the way it's supposed to. And likewise, for a number of other things that have been asserted as harm in the Snowden disclosures, they were our sort of society and diplomacy and legal system operating as intended.
So let me ask you a follow-up question, which fits in naturally here from another member of the audience. And unless members of the audience tell me, I will not reveal their identity. But this person says, for the past hour, the conversation is concentrated on damage to the intelligence community. When is there going to be a discussion about the damage done to democracy by the collection of our personal data? Bart, you want to start with that? Maybe I'll ask Shawn then.
Well, this was the issue. The issue was that that the intelligence community, with the authority of Congress, although Congress did not, I mean, most members of Congress did not always know what was going on. But the US government collectively had breached old boundaries that had prevented them from doing things that found out about Americans. Shawn mentioned earlier something called incidental collection. Incidental collection is when they are going after a valid foreign target and happen to come across private information of Americans. The thing is, it makes it sound like a small thing, but it's actually quite enormous. There's just huge volumes of information because of the way the intelligence programs work, because of the way the collection systems operate. There are enormous volumes of private US information that gets swept into the system. I had access to a sample of about 100-some thousand actual intercepts under the 702 program. And we did a computer-assisted analysis of that material and found that for every foreign target in this database, there were 10 incidental bystanders. Many of them were American or US persons as they're described in law. And they don't throw that away. They don't throw away the American information, they keep it. And the public conversation was not always an honest conversation. So for example, Section 215 of the Patriot Act is the basis for the telephone call data records that were being collected. That was a law which said that the government may collect any business record if it is relevant to an authorized terrorism investigation. And so the US government came up with a theory that every record of every phone call by anyone in the country was relevant because it might contain information that they were interested in. And that was a definition of relevance that was so far beyond the norm in law or in common understanding that it sort of boggles the mind. And when it made its reports every year, the FBI would report to Congress in its open hearings that, for example, in 1997, I think it was, they reported we've only used this power 26 times. But it turns out that with 12 of those 26, you get 1 trillion telephone records of all Americans. So that's not really a very honest depiction of the scope of the program. And it's intentionally misleading. And that's why there were democracy issues here. I agree with the questioner very much.
Yeah, and I remember discussing this at one of the early conferences we had on this topic in 2015 while the ACLU v. Clapper case was ongoing with Chris Inglis, who was then second in command of the NSA. When I asked him about the fact that the 702 data was stored for a long period of time, he said to me, "Don't worry, we never share it with domestic law enforcement." And I thought, you don't? I mean, what if you really uncover a dangerous, potentially dangerous felon through this information? One would, in fact, in that case, hope you might share it with law enforcement, though I understand why this is a matter of civil liberties concern. Shawn, what do you think?
Wait, I'm sorry, I have to interrupt you. I'd be very surprised and distressed if he intended to say that they never share that information with domestic law enforcement, because first of all, it's in the minimization rules that they will share it if there's evidence of a crime or if there's evidence of imminent danger to someone, to the life or safety of an American. But
and that indeed is the answer. Yes, if there's.
Second of all, they do. I mean, the FBI routinely sifts through that data in the course of deciding whether to start a preliminary investigation against someone, because the idea is that although you could not target Americans for collection, you cannot purposely collect Professor Finkelstein's information. Once you already have it in hand, there's nothing that stops you from searching through it.
Shawn, do you want to say something about this issue? And is there a democracy problem with having collected the information in the first place?
I'll just say briefly, first of all, I think that it is a fair and completely legitimate question. And I think, we've often grappled with this question as we looked at intelligence reform. And one of the things I think that we all have to think about is that if we believe that there are authorities that the intelligence community has that allow the intelligence community to collect information, to collect data, that and that those programs are not in the best interest of our rights as Americans, and that they violate our civil liberty and privacy rights. One of the great things about being in this country is that we can say that, and we can raise that issue, and we can change that in this country. But here's what we have to understand. We have to be eyes wide open about that. There are so many examples where if the intelligence community or if law enforcement in this country had done some of the things that we've been accused of doing in terms of violating the rights of Americans, that we would have prevented horrible acts in this country. We know when we go back and look at, say, the Tsarnaev brothers, for example, when we go back and we look at their communication, we know that if we had been monitoring their communication in the weeks and months before what happened in Boston, that we would have been able to prevent it because it's all there. But we don't do that in this country. And so what we have to do is we have to think about this from the perspective of, if we're going to say, no, absolutely not, it is not appropriate that we collect this data or that data, then as Americans, we have to also be mature enough to accept that there might be consequences of those decisions, and those decisions, there may be impacts on our security in this country. I do believe that we can do intelligence, and we can also protect civil liberty and privacy rights. We can absolutely do that, but we're not going to always agree on what that looks like in terms of what's collected and what's not, and we have to be mature about the trade-offs.
I want to now put a couple of questions that came in together and ask about the third-party doctrine and how that impacts our analysis here, because a lot of the information that was originally being gathered under the Metadata program was being gathered from third parties. And we know as well that a lot of third-party data is given away wholly voluntarily, right? We give our permission to have our data accessed every time we open a new account, every time we use our cell phones for purposes of billing, every time we sign up for an internet package or engage in almost any sort of contract. And how much should that change our view of the problematic nature of these data collections? And in turn, of course, the justification for blowing the whistle on the program. Bart, do you want to say something about that?
Sure. So third-party doctrine is an exception to Fourth Amendment restrictions. It says it's a doctrine that in law that says it's not an invasion of my privacy to obtain information without my knowledge or consent if I've already given it to some other third party. It is intuitively nonsense. I mean, the law is the law, but I mean, in terms of our ethical intuitions, the idea that because I dialed a number and I therefore disclosed to the telephone company who I wanted to talk to, that I no longer had a privacy interest in who I'm talking to, you know, because I mean, this is a doctrine that swallows a lot of Fourth Amendment protections, and it leads to intuitively absurd results. It is not, however, what justified the Section 215 program. In fact, there were constitutional analyses done of 215 by lower courts, but they conflicted and were never resolved because it was found unlawful on statutory grounds. So, I mean, I don't want to take up too much time, but third-party doctrine is something that is a pet peeve of mine, actually, because I think it tells us that we don't intend privacy for things that we obviously do.
Shawn, what do you think about that? Do you take a different view of information that Americans give away, incautiously or not, and then the ability to access those through private companies, which after all have an enormous amount of information, especially about our internet behavior? Just think about social media companies and debates that we have about that regularly today.
Well, I tend to agree that the tenets of third-party doctrine on its face is somewhat questionable in terms of what our intent is when we provide information. But I will, I often remind people that, for all the discussions we have about the intelligence community collecting the data on private citizens, we all know that we give away immense amounts of data to corporations, companies all the time. And that is absolutely in no way to suggest that that it's different. But what we recognize is that the amount of data that the intelligence community collects on anyone, anywhere, is vastly inferior. It's a lot, it's nothing in comparison to what we give away. And so when we think about this, I think about the business records program. It wasn't a program where that yielded a lot in terms of intelligence value. Collected very little data from my perspective. But what we give away on a daily basis is much more significant. The difference is we feel very different about the government having that information in comparison to Google or
And
Apple.
should we, Shawn?
I think we should. I think we should. Look, our government, government serves a very a clear purpose with regard to its citizens. And if I give away all of my private information to Google, I have a different expectation of what Google will do with that information than I do with with regard to the government. Now, I don't feel good about either having that information. But here's what I think we can all agree is that just because I give that information willingly to Google, or because Google collects that information because I don't have the patience to read the privacy agreement or the terms of service, that does not mean that I am okay with the government having that information. I do draw the line there and say that one does not equal the other.
Bart, what do you think about that? Should we care fundamentally whether it's the government that has our information or whether it's a private company that does?
Well, I think there's a distinction, and I think we do care differently about it. The government works for us. There's information is power. It is a distortion of the power relationship for the government to know so much about us and us to know so little about what the government knows, which was the status quo before Snowden. It's slightly over broad terms, but that's the general idea. The reason I called my book Dark Mirror was to allude to one of those interrogation rooms where it's a one-way mirror and the watchers can see everything about you and you can't watch them watching you. And that's not a healthy relationship in a democracy for the people to have to their government. On the other hand, people don't blithely and happily pass along all their private information to private companies either. In fact, the more they know about what the companies know about them, the more creeped out they are. And it's not a question of saying, well, if you don't want a company to know something, don't post it on Facebook. Facebook knows infinitely more about me than I say on Facebook. In my case, especially because I don't say anything on Facebook. Nevertheless, I mean, and for example, I would never give Facebook my personal cell phone number. But Facebook probably has 100 copies of it because it has inveigled lots and lots of people to upload their full contact lists. And so friends of mine, no doubt, have, without really fully understanding the implications, handed over their whole contact list to Facebook. So they now know my number. They know which numbers are in common between me and a billion other people in the world. They collect information by machine reading from your computer, by following you around the internet with little JavaScripts that appear on most sites. And the more you know about what they're collecting and how they're collecting it and what they're doing with it, the more creeped out you are. And so I don't say, you should worry about one and not the other. I'd say, why choose?
And Claire, I just want to add to that, Bart's right in that, they know more about us than anyone. When I think about the threats, when I think about risks that we all face, I don't think it's an overstatement. I personally am much more concerned about the amount of information that Google and Facebook and Twitter have about me than I will ever be about the amount of information the government has about me. And the reason is because, you know, look, despite what people may believe as a result of what the president says or what as a result of the NSA articles, the government is not actively engaged in collecting every tidbit of information about you it can possibly collect every hour of every day here in the United States. It's simply not true. It's simply not the case, but it's very different for a lot of these big companies.
So we need to wrap up. I want to ask one last question to close our discussion tonight. A frequent criticism made of Snowden is that while it might have been justified to reveal the fact that our government was spying on Americans and that this was an unjustified and an illegal program, nevertheless, he did not do what it is normally recommended, indeed required that you do when protesting such and expressing such concerns, namely to move up his chain of command and to report this up the ladder, and only go to the press when you have tried every other possible method of registering your objections. Bart, is that something that you believe he should have done, or was it justified for him to turn to the press immediately as he was thinking about these programs and wanting to bring them to the attention of the American people?
Well, I mean, there are lots of interesting questions about Snowden. Since he wants to characterize himself as a whistleblower, why did he not, in the tradition of civil disobedience, turn himself over to government authorities and say, "I've done something,
Another good point.
but I accept the consequences"? Or why didn't he go to his superiors? Well, I understand the question. If you think about it, it is not exactly that kind of a case. It's not that he found that in the vast universe of things the NSA was doing, there was this one thing over here that looked like it was a violation. His objections and the things that he wanted the public to talk about would be the equivalent of going to his boss and saying, "Good God, man, I mean, everything we're doing here is just horrific." I mean, it didn't fit within a normal whistleblower framework or the kind of thing you could complain to your boss. So saying, you know, our whole approach to intelligence gathering here is fundamentally wrong, is his point of view. He also did not believe, this is one place I differ from him, he did not believe that the only scandal here or the only thing to criticize would be surveillance of Americans. He believes that everyone in the world has the same rights of privacy. That was not my premise as I was reporting this story and as I was writing this book. And I talk about in the book why that's different for me.
And so, Bart, do you think the magnitude of the program actually justified his turning to the press? And if so, do you think he deserves a pardon? Was President Trump right?
I've never said whether I have a position on Snowden being pardoned. I haven't really felt that it's my place to do that, considering that I was a journalist who benefited from him as a source and learned a great deal that I thought was worth publishing. If I did not think that it was in the public interest, I would not have written the stories. I wrote a lot of stories. So I believe that public good was done. And it is the case that under the structure of the laws that charge him with crimes, he has no public interest defense. He can't say, yes, I did it, and here is why. Here is my reason for believing that it was in the public interest. In fact, if Snowden were able to come into court, and he's not, this wouldn't be true. But if he could say, every single program that I disclosed without exception was found unconstitutional by the Supreme Court, he would still be guilty. And that would not diminish his guilt in any way. There is no public interest defense. And so he can't get a trial that would fit my conception of justice in this case. But the law is the law.
Shawn, I'll give you the last word on that. Should he have reported up the chain, and were his revelations to the press justified?
I think Bart would agree that Edward Snowden sees himself as a smart guy. And I think that there are certainly ways in which he could have gone about exposing what he believed to be mass surveillance on the part of the National Security Agency without doing this exactly the way he did. And here's the question I always come back to, Claire. If Edward Snowden was really, truly concerned with exposing what he believed to be mass surveillance, both here in the United States of Americans and people around the world, then we have to ask ourselves, why is it that Edward Snowden took so much that has absolutely nothing to do with surveillance of anyone? When we look at the trove of documents he took, we look across the board and we see things that even in the most stretched out wild imagination, you could never say has anything to do with mass surveillance. And I think that from that perspective, that we all have to look at Edward Snowden, and we have to question whether or not, even if there are people who believe that what he did was justified, we have to question whether or not his only motivation was to call wrongs on the part of the government to the attention of others. I would say that there's enough evidence to suggest that it wasn't.
Thank you so much to both of you. Bart, it's been absolutely fabulous having you with us virtually. I hope when we can invite you back in person, you will return and no doubt be talking to us about your next book. But it's been a great pleasure having this conversation. Shawn, thank you so much for engaging as well and allowing us to have a bit of a debate around these issues. The book is an absolute page turner. If you have not read it yet, I urge everybody to go out and buy it. And while you're waiting for the pandemic to pass, you'll have a really good read ahead of you. So thank you so much to all of you and to all the members of our audience for joining us tonight.